welcome. We're all on our webinar with Hadley Arkes and Arthur Milikh, and it's co-sponsored by the Heritage Foundation and the Intercollegiate Studies Institute. So if you've been on any of these with me before, you know the rules. Try to keep it as civil as possible in the chat. Don't say anything rude to anybody else. The one big rule, and I'll say this a couple times, is if you have questions for the speakers, drop it in the Q&A tab next to the chat. If you want to talk to each other, if you want to tell me, yeah, my tie looks great, then let me know in the actual chat. But questions for the speakers go in the Q&A. If you're watching us on Facebook Live, we're gonna pin a link to the actual webinar into the comments for that, and I encourage you all to go and sign up for the actual conference so you can communicate with us. If you're watching on the webinar, jump into the Facebook Live and share it so that way other people can see what we're doing and perhaps join us. So with that little quick housekeeping rules, I'll introduce my co-sponsor, which is, oh God, Kelly, I have to say your last name now. I'm going to let you say it. It's Kelly from the Heritage Foundation, and she's going to very briefly tell you about her organization and introduce a quick video. Kelly, what's your last name?
Bapavog. Thank you, Tyler. So, hi all. My name is Kelly Bapavog, and I'm the Outreach Coordinator for the Young Leaders Program. I'm also an ISI student, current honor scholar, so very excited to bring this partnership together and bring kind of two of the leading voices on free speech here together tonight. And with that, I just wanted to give a kind of quick introduction to the Heritage Foundation. We focus on building an America where freedom, opportunity, prosperity, and civil society flourish by performing and marketing research on key policy issues to audiences of Congress. And at the end of this webinar, I'll give a little bit of information about our flagship internship program and an educational academy that we're launching this summer. But for now, I'll just show a quick video to give you a little bit of background on what Heritage is and hand it back over to Thomas.
We are coming together at a crucial time in our nation's history. America is making great strides towards freedom and liberty, but she also confronts determined foes and faces enormous challenges. Challenges that strike directly at the core principles that all of us here hold so dear. Free enterprise, limited government, individual freedom, traditional values, and national security. Across America and the world, we see where liberalism has left its devastating mark. In homes, in schools, in communities, and in capitals. That's why our work is so important, and it's what the Heritage Foundation is all about. At Heritage, we're not just a bulwark against the left, we're a battleship for liberty. We are determined to guide America to renewed greatness and to take the fight to liberalism. That's why I'm so proud to serve as the Heritage Foundation's president, and why I'm so honored to join with you in the fight for the greatest nation on earth.
Okay, great. Well, thank you, Kelly. That was a great video. I think, we all know and love the Heritage Foundation, and, we're proud to be a co-sponsor with you guys. I wanted to say something very briefly about ISI because I know some of you came in through Heritage and may not know as much about us. ISI was founded by a man named Bill Buckley in the 1950s with a really, lofty goal of trying to introduce, keep the intellectual conservative tradition alive on college campuses, which is a challenging thing to do. And we do it by, not trying to control the way anyone thinks, but try to make sure that the conservative canon is available to college students. So if you're not a college student, lots of ways to stay plugged in with us. We publish books. We have our famous periodical Modern Age. I encourage you to go to our website and read our content. But if you are a college student and you're inspired by ideas and you would like to learn more about the conservative canon or the Western canon, join the ISI chapter in your college campus. If there isn't one, start one. You can be a founder. There's free books. There's amazing events that we will sponsor and help you run. really encourage everybody to get involved. And if you're inspired by political philosophy and also by this free speech issues, I would encourage you to join our collegiate network, which is our network of campus journalists, and fight for free speech on your campus that way. So that's it. So that's my whole ISI spiel. And so with that, I guess, Kelly, I'll see you later. And I'll move on to introducing our speakers. We do introduce people, if people have been watching my previous webinars, we do introduce people with memes here. Unfortunately, I'm sorry, guys. So this is the meme I came up with for the two of you. I think it's something we can all agree on is, what the sort of common enemy is, the, thought police double speech issues that come from this free speech problem. We have a really interesting conversation lined up for you guys today. I think that free speech is one of these issues that everybody maybe at first feels like they're on the same page of, but becomes very sticky when there's the line drawing problem of when it should be restricted, if at all, and when it shouldn't. And even in cases where there's something very inappropriate and you do want to restrict it, allowing those sorts of powers be twisted and manipulated by the other side in other situations. So I expect that, I'll take this meme down, guys. I expect plenty of agreement and some disagreement from our two speakers, but I will let the two of them tease that out as this goes on. I'm going to introduce them both at first, and I was told to keep my introduction short, so I'll say this about Arthur Milikh, is that he's the Associate Director of the Heritage Foundation for the B. Kenneth Simon Center of American Studies, and his focus is on America's founding principles. And Dr. Hadley Arkes is the Edward N. Ney Professor of American Institutions Emeritus at Amherst College and the founder and director of the James Wilson Institute. You can find their full bios on their website. And Dr. Arkes has told me to mention as well that he's the author he wrote the book on First Things. He's the author of the book First Things, which I know is where the magazine took its name. I think it's also where the magazine took its font, if I'm not mistaken.
Right.
And
that's right.
So we've got some great speakers on this topic of free speech. Dr. Milikh, I'll hand it over to you first and give you 20 minutes to open up the conference.
Okay, well, thank you. But one point of correction, I'm not a doctor yet.
Mr. Milikh.
So yes, thank you very much. For all of the people that have worked hard on writing and finishing and defending their dissertation, they would be offended by giving me one prematurely. First of all, I want to thank you very much for the introduction. Thank ISI for setting this up, hosting us, inviting me, and inviting Professor Arkes. For those of you listening here, you should know that it's really an honor to be on the stage with Professor Arkes. I've read his writing for many years. I'm a great admirer of his, and he's a real legend whose work you guys should get to know. So what I want to tell you guys is that many of you, I presume, have done internships in DC. And when you show up in DC, you meet all of these policy experts, and all of them are trying to sell you on how important their little policy issue is, and how if this one piece of legislation is passed, if this one administrative agency is killed, all will be well in America. I think they almost always exaggerate in these regards. And so the burden is on you to figure out the real hierarchy of issues that matter in America today. And I think that speech is just one of these most important ones. It's a civilizational level issue. And if the freedom of speech disappears in America, I think it's basically over for us. And there's a huge front forming, as maybe some of you have already felt, especially on your university campuses or on social media platforms, where you guys see that there's a large front that is uniting, expanding, growing in its power and growing in its capacity to persuade the American public that so-called hate speech should be either outlawed or banned or criminalized. Now, I am, in addition, it's not just domestically. there are also very powerful forces abroad that are trying to push us in this direction. So the current UN Secretary General has said that it's his greatest mission to stop all of hate speech. The European Union, almost all of those nations ban so-called hate speech, as does Canada, and they're always putting pressure on us to attempt to restrict our freedom of speech. And the Democratic Party is going to be coming out more and more openly, though it already has to some degree, as the party that stands against the freedom of speech. Now, what I'm going to try to do is to articulate for you the theory by which the left understands hate speech and how our political discourse would be completely circumscribed should their proposals come to pass. Now, hate speech, you should know, has nothing to do, in my opinion, with racial epithets or Holocaust denial. Those are just the public arguments given for your wine aunt so that she won't feel bad when it comes time to get rid of the freedom of speech. It has nothing to do with that, really. What it has to do actually with is taking away the speech of so-called oppressor groups for the sake of letting the marginalized or the victimized speak. That's the theory beneath it, and I'm going to sift it out for you guys. Now, to do that, I kind of want to take you on a quick tour of Europe and Canada to show you what it's like in these other countries. They've started to implement hate speech laws in about the 60s, but it really has revved up in the previous couple of decades, and it's going more and more in this direction lately. They're still in the midst, in other words, of this experiment. Now, even though all of these countries have criminalized hate speech, they still can't really define it. What they call hate speech is something like incitement to hatred. In other words, our laws, by contrast, protect people from incitement to violence. But what their laws want to do is prevent incitement to hatred. Now, you may think that that's vague, but it gets even worse. Some of their official documents also say that hate speech, forget that it can incite people to hatred when it's said in a full-throated, outright way. Not just that. In addition, hate speech, I'm quoting, can also be concealed in statements which at first glance may seem to be rational or normal. So what kinds of speech are they criminalizing? Well, it's kind of the stuff that you would guess. It's speech that's deemed racist, anti-trans, homophobic, anti-religious, xenophobic. In Belgium, they even criminalize sexist speech. And they define it as any, not just speech, but gesture or action intended to express contempt towards someone because of their sex. So what are the punishments in some of these countries for this kind of so-called hate speech? Well, there are fines in the thousands of euros. Homes have been raided. Arrests have been made. People's lives have been destroyed through lawsuits. Not just public statements of these kinds of speech, but also private statements of hate speech are enforced by these laws. In Canada, too, Canadian law says any notice, sign, symbol, emblem, or other representation indicating discrimination or an intention to discriminate is punishable. So in other words, the law will think through what your intention was so that you can't avoid its teeth. Now, in Europe, these laws don't actually work in doing what they purport to doing. For example, stopping violence against oppressed groups. So I'm Jewish, and in the UK, you are 13 times more likely than in the US to be a victim of anti-Semitic violence. In France, it's 4 times as likely. So in other words, in countries that claim that by silencing hate speech, those groups, those so-called marginalized groups will be safer, it's actually the reverse than in the United States that doesn't criminalize hate speech. And these societies, surveys show, are full of discrimination. So these laws don't actually do what they claim to do. But one thing that they end up doing is creating far right and far left groups that end up thriving in these countries because both feel so oppressed that they can't actually reasonably speak their mind, that they have to organize underground against these kinds of things. Now, you may say that in America, things are different. After all, in 2017, we had a ruling called Matal Vitam, which was unanimous in stating that speech that is offensive to a hearer is protected by the First Amendment. You may say that sounds pretty good. Things are different here. But I would urge you to reconsider that. The reason is that there are already very strong precedents in two kinds of laws embedded in American law today that could very easily lead to the criminalization of so-called hate speech. The first is anti-discrimination law. Anti-discrimination law is more and more getting into the business of regulating what is said in workplaces. And employers, even if they don't actually feel compelled, are beginning to do so because of the threat of those laws and the desire, the moral desire to comply with them as they set the kind of moral standard. The other, and this is just as powerful, is the, if you trace out, and Professor Arkes knows this as well as anyone, if you trace out the logic by which sexual liberation took place in America within the legal framework, many of those opinions were based on an interpretation of the meaning of the word dignity. And dignity ends up meaning our capacity to define ourselves and our ability to place the burden on somebody else to legitimize my identity or my dignity. So things in America may seem fine, but those precedents exist. And the point is that these laws aren't just written overnight. There's an entire propaganda campaign that takes years and years to persuade the public of the goodness of this kind of stuff. You know, the universities persuaded over the course of 2 generations many Americans to take up ideas, policies that they otherwise wouldn't have. So the real battleground is not so much in the courts, but in the culture, especially in the universities, and as I said before, in the tech world. Now, I want to leave behind Europe and Canada for a moment and focus on the main arguments that the left makes by which they claim that the criminalization of hate speech is necessary. So the first is that it leads to physical harms. Okay, what does that mean? That means that those who experience hate speech have a tendency to depression, to drug abuse, to strokes, to heart attacks, to high blood pressure. Every imaginable ill or pathology can be blamed on these kinds of external causes. And as I mentioned, if some advocates say that concealed statements can bring about these effects, the limit is, well, there isn't a limit. Anybody exposed in the most distant way can make claims to these kinds of harms. The second is that the left claims that hate speech excludes people from politics. In other words, this means that if you are hated in a political community, you cannot have full participation in that community unless you feel welcomed and even celebrated. Now, you may say, this is baloney. We have civil rights, we have voting rights, we have the freedom of speech, by which I mean we have the capacity to persuade our fellow citizens to see our side. But as the theory goes, a minority cannot speak to a majority because of the power differential between the two groups. This means that the marginalized cannot reason with the majority because reason, according to this segment of the left, is connected to power. Their minds, in other words, are distorted because they have so much power over others, over the marginalized. And what that ends up meaning is that this distorted, deformed majority must be compelled. Now, of course, advocates for criminalizing hate speech never articulate why it is that the alleged oppressor's reason is distorted, but not that of victims. Victims end up being pure, innocent, and we must #believe them. And in that pure innocence, they have a perfect understanding of justice, whereas the powerful oppressor is deformed and distorted and must be compelled to see their side and not through speech because they can't be persuaded. Now, the third claim, and I think that this is the most interesting one, the third claim is that hate speech harms dignity. Now, Everybody hears this word dignity. And look, when you hear it, you can't help but be sympathetic to it. Like, are we really against dignity? Is dignity such a bad thing? Well, that's not what I'm saying. But what I am saying is that this view of dignity is a very bad one. And here's how I like to think about it. Dignity is this contemporary concept used especially by political theory professors who are seeking a solid ground on the basis of which to find what is permanent and respectable about human beings. And they want to do that without rooting it either in human reason or the soul. So in America, we have two traditions of dignity. The first is the one that we get from the Bible. We have dignity because we have a soul. We're connected to a divine order. The other is the one taken from Locke and the founders, that dignity is based in our rational faculty. And what that means is that we have forethought, and therefore we can be held accountable for our actions. That is in what our dignity inheres. But the new view is very different. The new view, I think, is best summarized by a very famous professor named Charles Taylor, who says that dignity is the potential for forming and defining one's own identity. And to deny somebody that identity is a moral wrong. In other words, I'll put it this way. All of the so-called marginalized have been given an identity by the oppressor. And the burden on them is to liberate themselves from that identity. And once they liberate themselves and create their new identity, that identity becomes sacred. It cannot be touched or criticized. Now, the key is, in creating this new identity for the marginalized, is that others must recognize your identity as you would like it to be recognized. In other words, others must respect you as you would like to be respected. And what that means is that all of those marginalized groups who are creating new identities must be celebrated. Celebration is universal, except if you are an oppressor identity, in which case your identity should be taken from you. So that's kind of the theory behind it. And very quickly, I want to show you guys what the new speech regime, what its new contours would look like if it were fully implemented. And I think there are three crucial facets to this. So the first thing to remember, as I've kind of mentioned already, is that this speech regime is a one-way street. In other words, it means that the marginalized are free to say as they please, not only about themselves, but about the oppressor. But it's only the oppressor group that must be silenced. In fact, to add to that, there should be speech against the oppressor majority, since they are the oppressor, and since their identities are the cause of oppression. And by dislodging those identities, you thereby develop your full dignity. And in this regard, cultivating hatreds and falsehoods against the majority is perfectly permissible. And by the way, these are not my words. These are the words of all of these theorists. I mean, in case you guys haven't caught on, in America, the oppressive majority are whites. Those are all of their words. I don't even need to prove by some implication that that's what they mean. They say it. It's white Americans. And if you are white, then by definition, you are a kind of white supremacist, whether you acknowledge it or not, because you have all of the white privilege that has been built up in all of the white superstructures from which you benefit. So that's number one. It's a one-way street. Number two, what would become impermissible are factual claims. So I know that this sounds a bit bizarre and a bit like, conservative tin hat Yahoo, but it's true, and a lot of them say it, and I'll give you guys some examples. So why can't you make factual claims? Well, because certain factual claims harm the dignity of the marginalized. What are some examples of that? Public discussion of immigration. To say that you want to limit or restrict or completely shut off immigration would harm the dignity of our, as they like to say, of our vibrant immigrant communities. To talk about the disparate outcomes between children born into whole natural families and not would harm feminists, gays, and lesbians. To talk about disparities in crime even if these things are all factually demonstrable, would still harden the dignity of certain groups. So then you say, okay, well, public discourse then would really be circumscribed. So what then is left? Well, not a lot, because then you go to this next level of things that would be permissible, and you think, okay, well, at least we can talk about public policies like welfare policy. That's where you'd be wrong, because that is a racist dog whistle. Because as the left likes to say, those kinds of policies disproportionately affect one marginalized group over another. And so it's absolutely not clear where public discourse would take place. The whole point is to get rid of public discourse. It's a very great danger to much of what the left would like to do in this country. And the third and final point that I would like to make, in terms of what could no longer be done in this if this new hate speech regime was implemented. Remember I told you guys that the idea is that the marginalized must shed their false given identity that the oppressor group has given them, and they must create a new one. And what that means, in effect, is that they have to create a narrative, as they like to say, or a better word is a myth. They have to mythologize themselves. And in mythologizing themselves, what they're doing is giving themselves self-respect, as in, look at my beautiful, dignified origins. And they are convincing the oppressor majority, look at my noble, dignified origins. And so what will become impossible is to criticize those self-anointed mythologies. So here's one example. I think that it would become impossible to criticize this notion that all of history is a male conspiracy of patriarchy to oppress women. Similarly, maybe you guys saw the 1619 project that the New York Times published last year, I guess it is now, whose purpose is to kind of create a false history that says America is fundamentally racist in its DNA. So that would be another myth that is meant to give dignity to a certain group that could no longer be criticized, even if it is factually incorrect. I think I'm running out of time. Just one final thing to conclude. I hope you don't take me to be suggesting that we should be unkind to our fellow citizens and gratuitously vile to them. I don't at all believe in that. But what we're fighting for is to preserve this realm of political discourse that is absolutely necessary for a free people to govern itself. And you will never create this utopia of equal dignity and equal self-respect by compelling an entire group to believe falsehoods about other groups. It doesn't create equal dignity. It creates hatred and rebellion. So I'll end it there, but I very much welcome your questions. Thank you.
Okay. Well, thank you, Mr. Milikh. I'm going to hand it over to Dr. Arkes. I just want to remind everyone, people who are just plugging in now, that if you have questions for the speakers, I'm going to bring up your questions after Dr. Arkes is done talking. So drop all your questions in the under the Q&A tab. So use the chat to talk with one another or to tell us if your computer's not working or anything. Use the Q&A tab for any questions you have for our speakers, either Dr. Arkes, Mr. Milikh, or both. So with that, Dr. Arkes, I'll hand it over to you.
Okay, thanks, Tom. Thanks for inviting me, and Arthur, thanks for the good words. I think Arthur painted a very precise picture. I, too, have been a target of the left for many years, the attempts to silence people like me on the campuses. But I have my point today is to warn us that we won't find the right strategy for the protection of speech by leaping to a scheme of relativism as a clever method. The people who know me know that over the years I've argued that comedians are in the same business as the philosophers, that they make their livings by playing off the logic and language. You think of Groucho leaving a party late at night. He stops to talk to the hostess and says, I've had a lovely evening. This wasn't it. We find that this is the logic of language is the key to the problems we face here. I begin with two vignettes. Vignette 1. I was in the courtroom of the Supreme Court in January 2012 to hear Seth Waxman arguing successfully for the Fox network over the matter of bad language on television. He was arguing against rules he regarded as too restrictive. The case involved these kinds of outbursts, and I'd ask you to forgive my language here. The singer Cher exclaimed, "I've had my critics for years, and I say, fuck 'em." The singer Nicole Richie said, "Have you ever tried getting cow shit out of a Prada purse? It's not so fucking simple." Now, in his argument before the court, Waxman sought to deny that there's any tenable ground for regarding those words as unfit for broadcasting. Yet Waxman carefully omitted speaking any of these words in the course of his argument. Now, why would he do that in the course of arguing that there should be nothing offensive or illegitimate about these words in public and national media? And what was the rationale for omitting them? In a second vignette, my beloved former colleague at Amherst, George Catheb, was addressing a vast throng in the college gymnasium at commencement, parents, grandparents, siblings, uncles, aunts. He chose on this occasion to sound again the cause of freedom of speech. And he focused on that single case of Cohen versus California, 1972, the case of a young man in a courthouse in Los Angeles wearing a jacket with the words, "Fuck the draft." He'd been asked to remove that jacket, and his refusal brought forth a case that made it to the Supreme Court. Catheb sought to offer an earnest defense of the freedom to use those words on the jacket in a public place, and yet he took care before this audience never to mention the words themselves. He described them simply as an epithet. My colleague, with his own sense of propriety, had simply backed into the common sense understanding that lay behind that legal ordinance that Cohen was violating. And it was the same understanding contained in that classic case on public speech that the court upended in Cohen versus California, the case of Chaplinsky versus New Hampshire. Evidently, my colleague didn't think those words were appropriate to speak in this public setting. He might have held back out of concern for those words could be needlessly upsetting. And as with Seth Waxman, he didn't think that those words were strictly necessary to the substance of the argument that he wished to put before his audience. And in both instances, we found these two estimable people backing into the logic of that classic case they were seeking to oppose, the case on fighting words. The classic case of Chaplinsky versus New Hampshire of 1942 was grounded in those axioms of common sense that we need to know before we can traffic in theories. It depended on what we understood about ordinary language, but it depended also on a pyramid of anchoring axioms or truths. And let me try to put some of them into place very quickly. The first is a deep, inescapable truth I find in Kant, that there's nothing we can name, no thing, no activity, that cannot be part of a means-ends chain leading to the inflicting of hurts on people. The skill of driving a car can be used to drive an ambulance or a getaway car for the mafia. A pen can be used to make a donation to a charity or to commit fraud. Now, is it conceivable that among all the things in this world, speech or speech acts, expressive acts, are alone incapable of being used to inflict harms on people? John Marshall famously said that even with the First Amendment, anyone who publishes a libel can be sued or indicted. He could be sued for libels that destroyed a man's reputation or business, or he could be prosecuted for the incendiary speech that incites violence against racial or religious minorities. And that merges with the second anchoring axiom, that strictly speaking, the understanding of an assault in the law has not required physical touching or material hurt. One could hold an unloaded gun to someone's head and click the trigger. One could shoot and deliberately miss. There are the threatening or sadistic phone calls in the night designed simply to elicit terror, or the burning of crosses outside the homes of Black families. Back in the 80s in Maryland, there was a case of a cross burned outside the house of a Black family who'd been away for the weekend. By the time they returned, the debris had been cleared up. The Black family had seen nothing, experienced no fright. But the neighbors and the other houses were left with the sense that something deeply wrong, chilling, had taken place in their own neighborhood. One does not need physical injuries to have an assault, which is exactly why certain verbal assaults have been regarded seriously as assaults on the same plane as other assaults or wrongs that we think it justified to reach through the laws. And that's why the material on projecting injuries that Arthur cites is essentially beside the point, if you think there's something in principle wrong with the assault itself. Okay. Now, Aristotle pointed out to us that animals too may emit sounds to indicate pleasure or pain, but human beings can give reasons over the things that are advantageous or disadvantageous, right or wrong. Human beings are by nature moral beings. They can't get through the week without going well beyond their personal feelings and pronouncing on things that are right or wrong for others as well as themselves. It's not only wrong for me to own a slave, but wrong for others, and others should be banned from owning them. What's distinct to human beings was language, and humans as moral agents will quickly come to an understanding of those terms in our language that carry those moral functions, the words that commend or condemn, approve or disapprove. Okay. At any given moment, some of those words may lose their pejorative quality, but at any given moment, if language is to function, the words that carry these moral functions must be clear to ordinary people who use that language every day. We can't just make up our own private language, walk into a delicatessen and order a fringe jack when we really want a corned beef sandwich. There will always be some terms to signal moral judgments of praise and blame. But in the same way, within that class of moral terms, there will always be some terms that have a special edge of insulting or degrading or defaming. That was described by Mr. Justice Murphy in the Chaplinsky case as those fighting words. And he put it this way. He said there are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. These include the lewd and obscene, the profane, the libelous, and insulting or fighting words, words which by their very utterance inflict injury or tend to incite an immediate breach of the peace. It's been well observed that such utterances are no essential part of the exposition of ideas. And at that point, more in a moment. Okay. But the point is that this test relied entirely on ordinary language understood by ordinary people. And as it turns out, you don't need a law degree for this. Truck drivers and construction workers may be as acutely alert as lawyers as to when they're being treated dismissively and insulted. And so the scheme works even better with a jury of ordinary people, and it can be set up in a libertarian way. We work on the premise that people have a presumptive claim to speak. We can tell a jury, convict only if Jones's words were clearly established as terms of denigration or assault. And in case of doubt, any words on the borderline, you do not convict. And then we give a panel, say, a list of these terms. Excuse me. Nigger, kike bastard, wop, urologist, meter maid, saint. Most people have no trouble in telling the difference and fixing on the terms that will be readily grasped as words of insult and derision, just as they would have no trouble telling the difference between a burning shoebox and a burning cross. Justice Murphy had remarked that those words or gestures could be banned without impairing the exposition of ideas or a serious discussion of serious issues. And so, Mr. Rosenfeld in New Jersey, at a meeting of parents with the school board, had one adjective at every turn: motherfucking. The logic of Murphy's argument is that Rosenfeld could be asked just to restrain himself for the sake of not wrecking the climate of civility and setting the setting for discussion. He could avoid expressions of that kind without impairing in the slightest way his freedom to give the most searing critique of the school board. And this was the argument that Seth Waxman confirmed yet again when he argued that case before the court. He sensed that those words were rightly unfitting in a setting of this kind, and yet his omission of those words did not prevent him from making a strong, substantive argument and winning his case. But the critical break from the teaching of Chaplinsky and the public ethic that Chaplinsky helped to preserve, the break came in Cohen versus California, with Justice Harlan and Coates-Jenkins saying, "Fuck the draft." Harlan's inventiveness came in rediscovering the doctrine of logical positivism 30 years after that teaching had been abandoned in the schools of philosophy. He too was now willing to argue that there's no stable cognitive meaning behind words that convey moral judgments. That is, there were no truths behind those judgments. They were merely emotive. They reflected the passions, the likes and dislikes of people who were emitting these judgments. That's where Harlan gave us the aphorism that one man's vulgarity is another's lyric. The meaning of these terms was so subjective that there was no principal ground for finding any one of them more offensive than another. But there was a telling discord that marked the incoherence of Harlan's moves. He was moving to protect Cohen's jacket as a species of political speech. But how did he know that Cohen was conveying anything political? If the meaning of words was subjective, well, fuck the draft could mean it could mean make love to the wind. Yet Harlan knew that fuck the draft was a term carrying the moral function of condemnation and contempt. And the condemnation could not be directed to the wind, but to a subject of political controversy. He knew that as the terms established in ordinary language as terms of moral condemnation and words that rebuked in a rougher way by their coarseness. Once again, people keep backing into the logic of the Chaplinsky case, even as they try to evade its argument. But in breaking away from Chaplinsky, Harlan brought about a simple, radical shift in the way that people can be together in our public lives. The understanding used to be that when we venture into public places, we could reasonably expect people to restrain themselves out of respect for the sensibility of others in a public place. But now Harlan and Cohen turned the presumptions around. We presume in favor of the freedom of people to act out in modes of expression, however wild or uncontained, and the burden falls to other people who may be shocked by the performance, to turn away their eyes, their ears, develop tougher skin, or simply avoid public places altogether. The urbanists for years have urged us to favor collective transport over the privacy of automobiles. But at the same time, the courts have been dismantling the moral framework of the laws that made these encounters in public less hazardous. My late wife, Judy, used to fly into Washington on Monday mornings and go through a battery of hawkers at the airport, making snide and rude comments. In the famous case of Snyder versus Phelps several years ago, the Reverend Phelps and his gang harassed the funeral of a dead Marine with signs saying, "Semper Fi, fags, and thank God for dead soldiers." In the days of Chaplinsky, the cops would have simply booted those hawkers out of the airport and told the Reverend Phelps and his gang to move on. Now, so for the record then, I would count myself then a member of that tribe who do not think that the republic would fall or that constitutional freedom would be impaired if a man could be barred from waving a sign in a courthouse saying, "Fuck the Jews," or if cops could simply tell the Reverend Phelps and his gang to move on. But we ought to be clear that this classic understanding of Chaplinsky did not permit the squelching of speech when it merely made people feel wounded or jolted. We could jolt people by calling them with news of a death in the family. They could be jolted by obscene calls in the middle of the night. But ordinary people with common sense can see the difference between a hurt inflicted as the byproduct of a legitimate call to convey important news, as opposed to a hurt inflicted to satisfy the sadistic pleasure of the caller. Chaplinsky does not give cover to the current fashions on campus to cut off speech that is critical of abortion or transgenderism because some people might be made uncomfortable about it. What came along with that classic understanding was the persistent need for a moral judgment on whether the speech generating these hurts was directed to ends that were justified or unjustified. And ordinary people make those judgments every day, nothing inscrutable about them. But out of the worries about the drift and the campuses and the new repressive instincts on the left that Arthur has chronicled, some of my friends have sought to counter the threat by leaping to the strategy of insisting that no judgment should ever be made about what is rightful or wrongful in speech. They've sought refuge, in other words, in a doctrine of moral relativism. My dear friend Justice Alito had been one of justice holding out against this trend until he finally fell in with the current carrying his colleagues. And so 3 years ago in the Mattal case, he's moved to say this, that the statute seeking to ban obscene or lewd names for products offends a bedrock First Amendment principle. Speech may not be banned on the ground that expresses ideas that offend. But that implies that offense is entirely subjective, that nothing ever done through the instrument of speech may ever be, in principle, offensive and wrongful. Those lines brought back to me the scenes from 40 years ago when I was called in by the ACLU to state the other side in opposition to their argument that they were making over a band of Nazis parading in Skokie, Illinois, in a community containing many Jews who survived the Holocaust. And Dave Hamlin of the ACLU said that the First Amendment protects all ideas, popular or despised, good or bad, so that each of us can make a free and intelligent choice. In Hamlin's translation, it was a matter of being popular or despised. To be despised was merely to be unpopular. It was no part of his understanding that certain things may in themselves be, in principle, despicable. For the conservative justices, this seems to be a tactical move, taken out of a sober recognition of the willingness of the left to slap the labels of racists and homophobes in a freewheeling way. The conservatives are trying to be pragmatic. But as the late Steph Evans used to say, the problem of pragmatism is that it doesn't work. If the premises of relativism are correct, there is no ground in principle on which we could say that this regime of constitutional freedom stands on any higher moral plane than a regime that denies that freedom at the root. And under the persuasion of relativism, the people imposing those speech codes are ever sure now that they can never be wrong, and nothing there holds them back. During the debate over the Nazis in Skokie, Dave Hamlin of the ACO said that we must be free to hear the Nazis because we must be free to choose the Nazis. The assumption, in other words, is that democracy is all process, no substance, that people were free to choose anything, to choose genocide, as long as it was done in a democratic way with the vote of a majority. In this understanding, the Nazis are legitimate for the American people to choose because apparently their ends are no less legitimate than any other sins on offer in our politics. But the freedom to choose in a free election arose from that proposition or anchoring truth that Lincoln understood as the first principle of this regime, that all men are created equal, that the only legitimate form of government over human beings must arise from the consent of the governed. But the Nazis rejected at the root that principle of all men are created equal and the regime of elections. For the ACLU to say, with the rest others now, that we are free to vote for the Nazis is to say that we're free to vote out this whole regime of constitutional freedom that the ACLU professes to defend. But if we're saying that, we're saying that all men are created equal is not what the founders thought it was, an anchoring, necessary truth, but merely one opinion, no more or less likely to be true than any other opinion on offer in our politics. By the time we find ourselves saying things like this, we would turn ourselves into a people who can no longer give an account of the moral ground of our own freedom. At a certain point, a free people must be obliged, as we used to say, to respect the premises on which their own freedom rests. But I have friends, smart and thoughtful lawyers, who accept the fact that we have standards of judgment, and yet there's a reluctance to have these decisions made by people in government with the authority of law. But if the concern is that the power to regulate speech may be abused and turned to wrongful ends, there's not a single domain of the law that is immune to that danger. If the possibility of abuse were enough to justify the withholding of the law, we could plausibly argue for the elimination of Social Security, Medicare, the laws on civil rights. But if there is a wrongful use of the laws, this point has to be made. The corrective should come in showing, with reasoned argument and evidence, just where the mistakes have been made. The corrective surely cannot come by flying to the conclusion that not even justified laws are warranted because we're no longer confident that people in public office have the competence to judge the difference between a rightful and wrongful use of the law, and mainly because we've come to doubt in this age of Washington relativism that any one of us has the competence any longer to make those judgments. The main corrective to this problem must always be found in a classic understanding of prudence. As Aquinas said, the law cannot correct every wrong or extirpate all evil. The law does all it sensibly can when it simply picks out for prosecution the cases that pose the most serious problems and teach the clearest lessons. So many tough-minded conservatives seem drawn to a stance of relativism as a radical ground of defense against the drive of the left now, in our own day, to stamp as a species of hate speech the arguments that conservatives would make on the most critical issues of the day, from abortion to same-sex marriage to transgenderism. But the pitch I'm making to you today is that the far more tenable ground for our defense is to draw the line at that critical difference that separates coarse, assaulting speech from the exchange of reasons in substantive arguments about those vexing issues in our law. So by this construction, we can say we could indeed bar that march of the Nazis to a neighborhood in Skokie. At the same time, we oppose no barriers to the publication of Hitler's Mein Kampf. Now, if we can't defend that line as writers and speakers, well, what in the world were we put here to do? But beyond that, if we can't defend that distinction, we can't just explain what we are doing when we're having this conversation. For this conversation makes no sense if we don't assume that we're having canons of reason at work, which give us the means of judging between the arguments that are plausible, implausible, right or wrong. We know that we're not simply shouting at each other, but giving arguments. And if we can't summon people to respect the moral grounds of their own freedom, our last line is simply to plead to them not to surrender the minimal furnishings of their own mind and the last thread of their own coherence.
Okay, great. Well, thank you both. I think you both had a lot of interesting things to say. We have a lot of action and activity in the Q&A tab, so lots of things to get to. Yeah, before I get to those Q&A questions, I'd like to just briefly kind of tease out a little bit of the differences in what you were saying. It seems like both of you had your sights set on issues with the left kind of trying to control free speech too much. But there are some differences here on this kind of dignity argument. So I wonder, Mr. Milikh, if you think that you are, I think we lost Dr. Arkes. So unless he can hear us. So I'll just ask you, I guess, the half of it that was for you, which was, are you being a relativist in this sense that he's talking about? Are you, by sort of not answering the question of what is and isn't hate speech, are you being a relativist on this issue?
Well, look, in a certain way, I'm sympathetic to to Professor Arkes's overall argument. It's very intelligent, and there's a lot of truth to it. The trouble is that I simply think that Professor Arkes is talking about a law suited for a country that no longer exists. Today, when you kind of take a look at the power structures that the left controls and how the freedom of speech is not only within their grasp, but also in their crosshairs, you see, in my opinion, such a standard as Professor Arkes has outlined would simply be untenable. And a lot of the European countries that have these kinds of general laws that, let me put it this way, the European laws don't say that you can't be homophobic, xenophobic, etc. What they say is that you cannot discriminate in speech on the basis of nation of origin, religion, sex, etc. So you would think that those laws protect all categories of people because they don't specify who they protect and who they don't. But in fact, because many of the courts are sympathetic to the underlying morality that I've just described, so are the government bureaucracies, so is the press, so are a lot of the big tech companies, and so are the elites. What you end up having is prosecutions that only go in one direction. The same thing in our university campuses. A lot of the proposals on the left would be modeled, their speech laws would be modeled on the kind that the European countries have adapted. And the truth is that a lot of those university administrators are simply not interested in protecting the kind of speech that I might be interested in. In other words, rational examinations of what a traditional family is and who it helps and why it's the only form of the family. Nor would they be interested in protecting the rational speech about immigration and what a republic needs or doesn't need. In other words, Professor Arkes, what I said in your absence is that I think that the kind of universal standard that you're proposing is very easily hijacked by the left because they control so many of the power structures that control speech today. I'll finalize this answer with just one example. Google, sorry, there was some video came up. Google controls 90% of the world's internet searches. 90%. They have no competitors. And when you look at their hate speech codes on YouTube, what you very clearly see is that they follow the logic that I've described. In other words, so do the universities, broadly speaking. The press already has a de jure speech code where they will destroy somebody's life for saying certain kinds of things and protect other people. So I actually think that those kinds of laws would not be universally applied, as Professor Arkes has said, but would be catered only to supporting one side.
Well, I think what you describe is quite no one's doubting that, Arthur. I mean, just a couple of years ago, the activists on the campus tried to bar me from speaking at the law school at Stanford, just on natural law, simply because of the positions I held on positions I had taken on same. No one doubts that. The question now is, what is the best defense of it? There are two paths. One could either try to embarrass these people by pointing out that what you are doing is trying to hijack the discussion by banning serious discussion of substantive issues. See, we could ban assaulting words. We could stop people from calling people gays and queers, while at the same time being free to make the arguments over the homosexual life. We can do that. But what my pitch to you is, we're not going to be able to find any plausible ground of defense by adopting the view that there's no ground on which we could call into question the substance of what anybody says through speech. Gunnar Gunderson found that marvelous passage in that writer of the left in Italy in a book in 1920, the great Benito Amicare Adriano Mussolini, who pointed out that the benefit of the doctrine of cultural relativism is that it shows us we cannot be wrong, and therefore we should not suffer any inhibitions in pursuing the fascist agenda. Now, I don't see how proposing now, undercutting the moral ground of our own position to say we cannot even offer a moral ground for the rightness of the regime's speech, why removing ourselves from that does not simply give a further a bit of weaponry in the hands of the other side to silence people on the campus. And even if we had this doctrine in our courts doing the right thing, there was a time when we used to recognize that the regime in private settings, private schools, private colleges, can be quite repressive. We will still not see Clarence Thomas or Sam Alito invited and welcomed on the campus at Amherst. The one president of Amherst said that if Clarence Thomas came, he'd need a food taster. We're not likely to see any, and even if we get these people to sign on to some doctrine of free speech, they'll be sure that it doesn't cover the people on the conservative side. So my pitch is that we're not going to find any real aid to our strategy and our cause, and we're going to undercut the moral ground of our own argument by taking this path. That's my concern right now, Arthur.
Okay, well, let me jump in and add. I don't think I need to take away from this conversation, just to add another element and to add one of our attendees. This is from Jenny Nugent. She asks, could you please speak on the relationship between reputation and dignity in relation to libel laws and hate speech laws, and why some instance would justify libel laws but not hate speech laws? I feel like we've been focused on hate speech for the most part in this conversation. Does this issue of libel change anything for either?
Well, you know, Arthur made a very good point about these people. He said they detach dignity from the moral tests. You know, so nobody should be made to despise his own life. Well, I think, yes, Himmler should have been made to despise his own life. You want to claim dignity for Himmler, quite detached from any moral judgment for the way he's lived that life. Now, James Wilson said that the government was brought forth to protect natural rights. And what do they include? Life, liberty, property, and reputation. That sense of dignity, the sense that ordinary people may have a plausible claim to preserve their own reputations, their own dignity, from the assaults of false speech. And under a trial, we have the access of testing the veracity of the claims. No, the truth is a plausible claim defense in cases of libel. So I'd say, yes, traditionally, for good reasons, we could protect people from those kinds of assaults as we protect them from other kinds of assaults. I give it over to Arthur, his angle on this.
Yeah. Hi, Jenny. I know Jenny. She, in fact, did some very good research for me on this issue, and she may even know it better than I do. point is that libel has to do with, as Professor Arkes said, your own reputations, creating falsehoods about you personally as an individual that may destroy your reputation and prevent you from enjoying your other rights. What some advocates for the criminalization of hate speech want is group defamation or group libel laws. The logic being that if you defame one person for the group that they are a part of, you defame thereby the whole group. So if you say that, I'm making it up, that certain groups produce more crime in the US than others, then by saying that to somebody about a group, you are nevertheless defaming that individual. And this is just a kind of legal strategy that certain academics on the left want to employ as a way of getting hate speech laws implemented through the courts.
Well, I think there's more to it. I did write a book in which that was a central point. I think we find ourselves back into that logic of racial defamation in many places. In the laws on fair housing, we had a provision for a while that barred people from putting up ads indicating willingness to discriminate on the basis of race in selling their private single-family dwellings, even when the law at the time did not bar that actual discrimination in those transactions. So that kind of law had a separate rationale, the rationale of putting up signs, no Irish need apply, or one sign in Syria, no Jews and dogs allowed. We can recognize that as a separate offense. Now, to say that it was a criminal, it does not mean you throw the people into prison for long stretches. In this famous Bohan Hay case, you may remember, where he was trying to incite people to resist the incursion of black people. Yeah, he was teaching a libel about all black people, but to focus, resist black people in your neighborhood. He was fined $100, and sometimes simply makes a tap on the wrist or some minor fine, just to make the point in principle that there's something wrong about doing it this way. And I think the case could indeed be made for that. But what you pointed out is that the other side is falling into the same scheme, logic of racial defamation. As you pointed out, Arthur, they are simply arguing out, if we know somebody is white, we know that he can't deal with black people in anything more than an injurious way, and anything he teaches about black people is bound to be defamatory and injurious, so on. But also let's remember, in the matter of libel, you could spread the libel that Moran is a dishonest car dealer. For all you know, his business was declining anyway. We may not be able to make a firm connection between the libel and any material injury he's suffered. Just as those claims where people make these specious claims that if we know people are saying things critical of on matters of race, we can impute to them all kinds of material harm. No, that's not plausible. But we had the recognition of the term of libelous per se. It is just maybe wrong to spread those words about Moran, the car dealer, even though we may not be able to show any connection between the insulting words and the material injuries he suffered.
Okay, so to sort of taking it in another direction, I'm seeing a lot of questions about originalism. One is from Jacob Little, and there's another one about from Nathaniel Bodnar about you read this article in The Atlantic by Adrian Vermeule, where he sort of attacks moral relativism of originalism. And Dr. Arkes, I know you have a bit of a natural law jurisprudence, and if you remember the argument against natural law is that it relies on the founders being right about natural law, whereas natural law is bigger than the real natural law is bigger than them. So I wonder, for both of you, I guess, but probably mostly for Dr. Arkes, where does your originalism have a relativism problem built in?
I've done a piece on the Adrian Vermeule thing. It'll be in the American Mind, but Arthur, Alexander Hamilton and John Marshall kept drawing their judgments back to those axioms, they called it, that underlay all their judgments, those deep axioms of the law. Things like, it makes no sense to cast moral judgments on people when they're incapable of affecting their own acts. We don't hold people blameworthy for acts they were powerless to affect. And Thomas Reed said that is true as any axiom in Euclid. The founders kept drawing on things like that. So that John Quincy Adams said that right to petition the government is simply implicit in the logic of Republican government. That right would be there, even if it were not mentioned in the First Amendment. It would be there even if there were no First Amendment. It would be there even if there were no Constitution. And Arthur, remember, Alexander Hamilton and the Federalists, 32, trying to explain why the Supremacy Clause, the Necessary Proper Clause, it's simply contained in the logic of a moral actor acting. He said those principles would be there even if they weren't mentioned explicitly in the text. You've got to understand that the founders, when they framed this Constitution, had an understanding of law that preceded the positive law. And they drew in all, look, there was Locke had this marvelous set of 3 questions. Remember? What is the source of the law? Well, the legislature that makes the law. Then what is the source of the legislature? Well, the Constitution that tells us that we have a legislature. How many chambers? But then what is the source of the Constitution? And Locke says it must be some source wholly antecedent to the positive law. So my complaint is that the people who call themselves originalists don't take it that far. They don't go back to the real understanding of the founders, the people who, the way that Hamilton, Marshall, James Wilson could trace their judgments to those principles that were there before the Constitution. That's where the natural law is. The principles that were there before the Constitution and would be there even if there were no Constitution.
That's a good answer. Well, Dr. Milikh, let me ask you a different question, or unless you had something to add to that.
No, I think that was great, Professor.
Hope so too. Well, let me ask you this one. This one comes from Daniela. She writes, how can we actively help the marginalized overcome their possible victim mentality so that they do not feel forced to censor their perceived oppressors?
So that is a nice question.
Good setup for you.
And look, I actually think that a lot of the so-called marginalized don't themselves feel marginalized. All of those arguments, right. All of those books are really written for white liberals.
It's true.
I mean, Ta-Nehisi Coates, this recipient of the Guggenheim Genius Prize, New York Times bestseller, writer for The Atlantic, has been elevated to the status of, the next in line after MLK. Who do you guys think reads his books? It's white liberals. It's academics. It's first-year college students for whom his book is required reading. So I actually think that a lot of these people, these so-called marginalized, experience their lives in very different ways. A lot of them are Christian. A lot of them still, kind of like this country, are grateful to it. Don't feel that, they're still continuously enslaved in white superstructures. I think the great push on the left is the hope that they actually come to believe those things. And many of them still don't. I suppose one could say, I don't want to put it this way completely, but the Trump election is kind of an interesting test case, the re-election on this. I mean, he's staked a lot in terms of cultivating a new black base. And whether that's successful or not, whether he's done enough on it, that's an open question. But the point is that I don't think a lot of those people that he's counting on voting for him actually experience their lives in these ways.
That's gorgeous. That's right. But the marginalized people are the black conservatives like Tom Sowell and Star Parker and people like this, or the black pro-lifers like Johnny Hunter, Reverend Hunter in Buffalo. He said they're covering the pro-life gathering, and when the cameras go off as soon as they reach the black pro-lifers. No, Arthur has it just so right.
I would just add one thing that, broadly speaking, there are two, it's not a perfect fit, but there are two categories of the marginalized. There are Blacks and Latinos, and I think I have broadly described them with some degree of accuracy. But then there are the LGBTQ, and many of them are white. And I actually do believe that many of them truly do think in the way, the logic of the morality that I described, that their self-respect, their pride actually depends on other people finding their sexuality respectable, that their entire identity comes to be built on a sexual act. And I don't know, I mean, that they may feel at some level that is not a complete identity. One can't really build an identity on that. So they do feel the need to stomp down any kind of, forget ridicule, forget, personal insults, but as Professor Arkes was talking about, rational arguments about, a way of life. So there are different kinds of marginalized peoples.
Father Newhouse made the point years ago that first it went from you shouldn't cast judgments on people. It's simply a matter of taste, say the homosexual. It's meant to be a matter of taste. Well, it's simply a matter of taste. The response is, well, it's not my taste. Don't impose on me. But what the argument moved from there to say, but it would be wrong for you to have that taste, so to bear that kind of reaction. So it moved quickly to the more argument. Of course, the whole point about relativism is that it's used to fend off any critical moral judgments. People don't want to have judgments cast on them, but of course, so they turn it right around. They can't resist making a moral argument. They want to make a moral argument for the rightness of their position. So of course they're in the business of casting judgments. But Arthur reminds me of that marvelous incident with Frederick Douglass when he was forced to ride in a baggage on part of the train because they didn't have a compartment for blacks, and some of the white passengers came up to him later which I'm so sorry that you've been degraded in this way. And he said, I haven't been degraded. Those are people degraded themselves. There are still black people who have that kind of confidence in themselves.
Okay, I'm going to ask we're pretty much out of time before we bring Kelly on. I'm going to ask one very quick question. This comes from Halima Griffin. He or she says that they are only 13, so they're not sure if this question will make sense. But what are the laws that you would use to achieve the goal of free speech? So in other words, would either of you be open to rewriting the First Amendment, maybe in the case of Dr. Arkes to add something about dignity or natural law, or in the case of Mr. Milikh to sort of, avoid provisions for hate speech? Would either of you be open to something like that?
Well, the founders didn't think necessary to do it because they seemed to understand that every instance of liberty looked toward an end, and they understood every aspect of your liberty could be used for a wrongful end. So every aspect of liberty carried the notion of license. You're aware that anything you do can be abused and sent in a wrongful direction. And so it just like John Marshall never assumed that the First Amendment would protect libelous speech. And look, remember, Hugo Black, who didn't want the laws on libel, an absolutist, would say, no, but you don't have the right to demonstrate in front of a courtroom and convey the impression that something going on in that courtroom is going to be affected by what you're doing out there. What's lost is that we seem to have lost the capacity to deliberate again about these. We talk about, Arthur put it well, they have notions of rights utterly detached from any ground of justifying those rights. There was a critical line of Justice Jackson, I really should have quoted her, I had it at hand, where he said at the Terminiello case, people need some assurance that the freedom of speech will not be abused to generate violence. And then he said, no liberty has ever been made more secure by teaching that its exercise was inseparable from its abuse.
Mr. Milikh, last word on this.
Well, not to go too much into Professor Arkes's point here, but the original view on the freedom of speech was that you belong to yourself, your mind belongs to you, and your speech as a product of your mind belongs to you. Now, that doesn't mean that there aren't limitations on it. Those limitations, broadly speaking, until, let's say, the 1920s, were obscenity, were libel, were seditious libel, and sedition. And those four restrictions all add up to a very important end, which is the preservation of political self-rule. That is what the purpose is. That's what the end of this was. And, we live in as I said before, we live in a different America than that America. And it's not clear to me completely that there can be a return on all those grounds today, even though, Professor Arkes knows that in many ways I'm in agreement with him and that I'm sympathetic to that. I'll give just one example. Professor Arkes said that he would like to ban certain words. Fine. The reasons behind that may be perfectly respectable. But as I said before, the left is not really interested in just banning racial epithets. That is just the public reasoning given to decent people who say to themselves, yeah, I don't want people mistreated, and neither do I, of course. The problem is not banning those words in particular. The problem is an attempt to ban the arguments that would harm the dignity of these various groups. These things are connected for the left. And because of the control that they have over the places that would decide that, that's where we get into this dangerous territory. And so in terms of changing the laws, that's what the original question was. I mean, at this point, my position is that for the next 50 years, if speech isn't banned by these major facets of American life, or let's put it this way, the places where actual speech takes place, like the internet and on college campuses, if we maintain some semblance of what we have now, I think that we can muddle through for 50 years or so.
Okay. Well, thank you both. It's a good note to end on. So I'm going to invite back in Kelly. Here she comes. Two of you, I want to thank you both for your time. It was really a great discussion. You don't have to touch anything. I'll kick you out on this. But appreciate that. What I thought was a really interesting discussion. There he goes, and there you go. Okay, Kelly. Okay, so you're back. It's good to see you again. Kelly, I've known you for a long time. I still can't pronounce your last name, apparently. I forgot that was something I would have to do on this. So sorry about that. But I'm going to ask you for a second to you work at Heritage now. You gave a good Heritage presentation earlier, but let's sort of take off that working for Heritage hat, and let's remember that you were formerly an ISI student, both an honor scholar and a member of an ISI society, which is our chapter on campus, and a former Heritage student. So why don't you tell me a little bit about your experience as a student of both of the Heritage College campus community and the ISI College campus community?
Yeah, absolutely. And thanks so much again. This was an amazing partnership. I really loved hearing from both Dr. Arkes and Mr. Milikh. It was great. But as we close out, as Thomas said, I just wanted to give a quick pitch for both ISI and Heritage. I interned at Heritage back in summer of 2018. Absolutely loved it. Obviously enough to come back and work for Heritage now. Their internship program is absolutely unparalleled, and you get to work with scholars directly like Arthur Milikh and go through an educational program and really get hands-on work. There's over 200 slots year round, and so I'd be happy to chat with anyone who's interested in that as well. And this summer, we're launching an educational program called The Academy, which will go over kind of foundational principles of American political thought and important policy debates. So everyone's welcome to apply for that as well. And on the ISI side of it, I was involved in our debate society on Harvard's campus. Absolutely loved it. Got to do ISI honors this summer. So Thomas, excited for your new class of honor scholars this summer. Unfortunately, they get to go to Malibu, and we were in rainy Seattle.
Fingers crossed that, that we make it to Malibu.
Fingers crossed that it happens. But absolutely encourage anyone watching to participate in ISI as well, get involved in your campus's ISI chapter, or start one, or even join the collegiate network. And it's a great experience.
Yeah. And then I'll just sort of add sort of my last minute plugs, which are, if you like this conference, we've been doing a ton of webinars. We're having a ton of fun with them. ISI, we have a couple coming up. We have on April 29th, I'm actually interviewing my father, who recently made a film on a documentary on Clarence Thomas. So hopefully you can see clips of the movie, and hopefully I'll get some chances to roast him during that. We're going to do, and that's on April 29th. On May 7th, conversation with Yuval Levin and ISI Vice President Jeff Nelson, and our conference on May 16th on science, scientism, and society. That's on May 16th. So those are coming up, but stay plugged into ISI's website to see new conferences as we keep coming up with new material and doing more of these webinars. I don't know if you have any similar plugs to add, Kelly. If not,
just feel free to reach out if you're interested in an internship or an online educational program this summer. Yeah, I'll drop my email.
Absolutely. Great. Okay. So with that, I just want to say thank you everybody for coming. I had a great time. This was a ton of fun. See you guys next time.